And like I said, I want to thank our speakers, Liz and Steve from the Fair Housing Center of Metropolitan Detroit and the Fair Housing Center of West Michigan. I want to thank Mishta, who is paying for their time to be with us today. And we would love it if you could use the Q&A for all of your questions, because we will be holding them for the end. Possibly a couple answers might get responded to via chat during the presentation, but it is much easier with a crowd as large as we have expected today to use the Q&A than the chat for the questions. Feel free to use the chat for reactions or to keep us informed with you signing in. That works for us as well. And we do have live transcripts, so if something you would like, you can turn that on. It is being provided during this webinar. So we have 185 people in here right now. The number keeps going up. We had over 400 registered. So we may not get to your questions, but we will try to get to as many as we can. These webinars usually end at 1:30 for those of you who are familiar faces, but today we're going to try to push it to 3 just because last time Liz presented for us, we had a lot of questions. So with that, I want to tell you happy Fair Housing Month, and I'm going to send it on over to Liz and Steve.
Thank you so much, Allison, and happy Fair Housing Month, everyone. It is really amazing to watch these numbers tick in. I appreciate the weather reports, and I know I should know better living in Michigan all my life, but somehow I am still very disappointed that it's snowing today, needing some of that sunshine and energy, but it's coming on the way. I'm really thankful to Steve for joining me today. We're going to trade off and on throughout our presentation, and we will try our best to save time for questions, but we have a lot of really good information that we wanted to dive into, a little bit more of a deep dive this time. So hopefully you had time to watch the 101 class from last year. If not, that's still available online. This will be made available online. We cannot see you or hear you. And as Allison said, this session is being recorded. Please do use the Q&A as we go through to submit your questions, and we'll circle back to those and have time for as many as we can at the end.
Sorry, Liz. I did have a poll to see who had watched it just so we could get an idea.
Great. Good idea.
I just butted in real quick if folks could answer this in a couple questions. So I did ask folks to watch it when we advertised, also when you got your registration, and then in your follow-up registration that was warning you yesterday that the event was happening today, we asked you to watch it, as well as we asked if you had any questions. So I'm not sure that people always read all of those emails, but just so you know, if you're coming to one of my events, I do put extra information in those reminder emails. So we have 61%. We're almost at 70, so I'll give it another second to see. So I appreciate you guys taking the time to fill this out. And it looks like a lot of people did not. So if you could share in the chat, if you just didn't have time or if you missed our request, that would help me out for sending information like that out in the future. I'd really appreciate that. I'm going to end the poll now. And it says, yes, I attended last year's session, 12%. I watched the recording, 26%. So that is 38% have seen it. 54% did not. So I appreciate your honesty. And 8% is not sure. So again, if you didn't see our request, please let me know. That would be helpful. Okay, back to you, Liz.
Thank you so much. And listen, I have to say, I understand so much. Seeing the names of the agencies and the geographic diversity we have today, we know that you are very busy people. So we certainly understand, but just want to make sure you know that's available as a resource. Nice of so many of you to have come last year and come back this year. I'm the Director of Education and Outreach at the Fair Housing Center of West Michigan, located in Grand Rapids. With me today is Steve Tomkowiak, the Executive Director of the Fair Housing Center of Metropolitan Detroit. Want to say hi, Steve?
Hi, thank you. Thanks for the opportunity to be here.
Yes, I'm very excited about this. Steve is somebody we have partnered with, worked with, and I continually learn from. I'm very grateful for his time and expertise, and to Micah for the invitation to be here, and also grateful for MSHDA funding to help us carve out the time to focus on this deep dive into fair housing. So we're going to move fairly quickly. So I do encourage you to use the Q&A feature, put those questions in there. We'll circle back to those. We're going to talk about the fair housing laws and protections very briefly, but really go into some of the more tricky topics. I think one of the issues about fair housing that many of us are aware of, having worked in some of the agencies that I'm seeing here, is that there can be gray areas. So we try to identify some areas where we don't have a lot of time necessarily, maybe in some of the trainings we've been doing, to focus on issues that have been identified, significant barriers, especially for the population that we're focusing on today, trying to help people who are unhoused, precariously housed, in a very, very difficult housing market. So we're going to cover a lot. So brace yourselves. We'll be looking at criminal background screening, source of income protections, program-based housing, gender protections, specific look at persons with disabilities, and a detailed look at assistance animals, domestic violence, and finally, unlawful self-help evictions and lockouts that certainly can contribute to homelessness. We'll share some resources and really encourage you to reach out to either of our fair housing centers if we can ever be of assistance. We would love to connect. So I'll briefly introduce our Fair Housing Center again in West Michigan. Is located in Grand Rapids. We cover 12 counties and really a little bit beyond. We have a map that will show you. We are a nonprofit, so we cannot give legal advice. We don't have attorneys on staff. We've been open since 1980. We have a very experienced staff dedicated to preventing and eliminating illegal housing discrimination, ensuring equal housing opportunity, and promoting inclusive communities however we can. I think in this group and this audience, you probably best understand that where you live directly impacts how you live. So being able to choose freely is something that we are very focused on. And as I mentioned, it's a very difficult housing market. So choosing housing freely that's attainable, accessible, affordable is challenging enough without experiencing that layer of illegal housing discrimination on top of it. So again, thankful for you all to carve that time out to learn a little bit more about this. I'll turn it over to you, Steve, to talk about your Fair Housing Center.
Yeah, well, our Fair Housing Center really parallels yours. First of all, you have an outstanding Fair Housing Center, so I'm glad to be with you.
Thank you, and ditto.
We date back a little bit earlier, back to 1977.
Yes.
Basically do some of the same work. You'll see that as we go through the slides, which list other Fair Housing Centers as well. We do have attorneys on staff, but typically we do not represent, but we have the option to do it. That's a new thing that we've done. But generally, no.
All right. So we've included contact information. There are 2 other traditional fair housing centers in the state of Michigan. So if you're interested in connecting with that group, there's Southeast of Mid-Michigan, which is kind of the Ann Arbor, Ypsilanti area. Fair Housing Center of Southwest, a little bit different from us, in Kalamazoo. We are happy to make those connections, and we've got the links to those centers here for you. And then, as I mentioned, we've kind of mapped out, with the help of MSHDA, the state of Michigan in terms of how we serve the state. There's also a legal services group in Flint that does some fair housing. They're not a full service fair housing center like the rest of us, but they are available as a resource. So this kind of gives you an idea. Steve is in the light blue there with 3 counties, and we are the purple. All right. Steve, you want to fill us in on some of the unfortunate data and some of the trends we're seeing in Michigan?
Yeah, I don't know if people realize this nationwide. There's a lot. Matt Desmond in his eviction project, I think it came out of Princeton. But anyways, nationwide, the annual eviction rate is about 67% of all rental households. This is not actual necessarily eviction. These are eviction filings. It's hard to say what occurs. It's hard to get the data what occurs after eviction cases filing. Roughly 1 in 17 renter households each year receive an eviction filing. With Michigan, we're off the chart, sky high. That may be an understatement. Our eviction filing rate, believe it or not, is 17%. That's approximately 17 evictions for every 1,000 households. The staggering 1 in 6 rate for every rental household. Within the counties, it even gets higher. I used our area, but some of the other ones, I think Genesee County is very high as well. Wayne County, 23%, Oakland County, 19%. Macomb County, believe it or not, 24.4. We're doing some work with Clinton Township, estimate their rate at 36%. Just stunning how many evictions. Detroit's getting attention with right to counsel and those kind of arguments, but it's higher in many other cities. 47% in Romulus, Inkster, Taylor. It's just stunning. It's just absolutely stunning, and it just does not get the attention it deserves. But you know, us here in this webinar, we experience it every day. Obviously, all of us know this is going on. Yeah, what are the causes of the eviction rates? Why is it so high? Why is it so high here? Again, the national poverty poverty nationally is 14.6%. Michigan is 36 percentile rate, slightly higher than the national averages. But 15.6%, 1 in 6.4 Michigan residents live in poverty. And believe it or not, 1.5 million report income below the poverty line in the last year. That contributes, and there's many other factors that contribute to poverty, homelessness, evictions, or I should say evictions and homelessness, inadequate education, housing opportunities leading to poverty, lack of affordable housing, and that is a concern or a critical concern that I just find stunning, that there just is not affordable housing and habitable housing. People are forced into on really uninhabitable property because they have no other choice. There's also housing insecurity. There's a couple, Zillow did it at 23% of your gross income. If it goes to housing expense, they start to see an uptick. And then once it hits the 31% and above, very, very insecure in terms of maintaining rental housing. That leads to eviction and homelessness. Matt Desmond points out that sometimes eviction is actually the driving force in homelessness, just because people may have a delay in getting income, or a paycheck could be late, or they could be between jobs and they end up being evicted, and then all the events that come from that. It destabilizes communities. I can't say enough about what that does.
Yeah, and I think this is a group that certainly probably could fill us in a lot more too, Steve, but this is a really important framework for the conversation.
Yeah, and the Michigan evictions, this was U of M, Taubman College, and others. Maybe Michigan Poverty Law Center was another group that would. So, but anyways, they didn't write this up. They were looking at just a problem of evictions. I'm looking at it like Liz would look at it. We're looking at it from the idea of fair housing. And what stuck out for me in their report, they found statistically significant correlations between the factors on the right and evictions, meaning the percent of the community or the percent of the tenants that were African-American, single mother households, percent of the population under 18. We're doing a poor service for our children, obviously. Percent of housing units that are vacant, multifamily structure. You can see the number of these, percent of households living in mobile homes. But the top ones show those are fair housing protected classes: race, single mother, that's sex, and marital status, percent of population under 18, that's familial status. You get the idea. So there is an underlying fair housing component. Not saying it accounts for all of it, but it's there. It underlies many of the evictions that we see. And these are ones that we've seen through various centers in Michigan and elsewhere, really, that underlying some of the eviction cases are fair housing violations. Non-renewal of tenancy is really suspect. People don't renew or don't issue non-renewals to tenants that have paid rent, been on time, haven't violated any rules, and then why are they being non-renewed? People are not non-renewed. There's always a reason. There's a reason why a non-renewal, and sometimes it's not expressed, but there is. I always try to dig and find it, go a step further, find out what the real reason is. Evictions for one or more rule violations that can be non-discriminatory, but if it's applied to one protected group and not applied to others, then it's a violation. Sometimes there's sexual harassment. Someone doesn't acquiesce, they get evicted. Domestic violence underlies some of the eviction filings. I've done a number of cases where emotional support animals, service animals have been used as a basis to deny someone and to move forward with eviction. There's occupancy standards, limit on the number of persons that can occupy a unit. They bring a child into the unit, and then that's grounds to issue a non-renewal or tell them they have to go up to a higher unit or whatever, but they're evicted from the place that they're in. And then other are just really targeting minority and other disabled and other minority groups. There's a lady that has significant disability, lived in a unit 14 years, hunk of the city, but she's being non-renewed. No rule violations, never been late, because they just don't want her because of her disability. It's a significant disability, but there's no reason why she couldn't be a tenant. Another situation is someone being evicted, believe it or not, because they're blind and they're considered a fire risk. She had a cigarette that smoldered. It was on her chair. She called the fire department. They put it out, no damage at all to the property. Now she's being evicted because she's blind. Well, I'm learning from this housing provider, apparently, if someone's blind, they're a fire risk. Is that the appropriate way to go? That's in another eviction case. So these are the kinds of things that we see. There are steps to address this.
Yeah, we'll talk about a lot. Yeah, we'll talk a lot about those issues on that wheel today in a little bit more detail. So in case you are new to fair housing, though, I want to back up and say what it is. You know, we are tied to fair housing law, which is the right of individuals to obtain housing of their choice, free from illegal discrimination based on protected classes that exist at the federal, state, and sometimes the local level. So it's important to differentiate. We don't work with tenant landlord law, although as Steve has pointed out rightly so, sometimes there is a discriminatory element to some of those situations, in which case we would partner with legal aid or whoever else is the expert in tenant landlord law, but that's not our expertise. We focus solely on who is protected. Is there a difference in treatment or an adverse action happening simply because of that protected class? That brings it under fair housing. So it's important to know the protected class list. This is something quite a few of you probably have heard me say in terms of whether you're looking to comply with fair housing law or looking to advocate for people. This is the list of protected classes that exist at the federal level, which is across the entire country, across the United States. It's illegal to discriminate against someone in housing because of their race, their skin color, their national origin, meaning where they are from, if they have an accent, things like that. Sex, which now includes sexual orientation, gender identity, and transgender status as a result of a ruling last February, some guidance from HUD, expanding that existing definition to include these elements. Religion, physical or mental disability, familial status, meaning presence of children under the age of 18. Federally funded housing has more in terms of compliance with fair housing under HUD's equal access rule, which prohibits discrimination based on marital status, sexual orientation, and gender identity. That's been in place since 2012. Here in Michigan, we also have additional protections from the 1976 Elliott-Larsen Civil Rights Act, which further also prohibits marital status-based discrimination and age discrimination, with the exception of senior housing, which is protected by Housing for Older Persons Act, or HOPA. You can have a threshold of 62 and older or 55 and older with some details to that, but generally those are the only two acceptable age restrictions. And then in terms of finding out what the local laws might say, there's well over 40 cities or municipalities in the state of Michigan that have some sort of local fair housing ordinance, and that's something we can help you parse out or look for. You can check with your local government, check with your local fair housing center. There's a couple of links here to some free code sources online where you can look up the different communities alphabetically and see if there's a fair housing ordinance. But really, you know, we're talking about who is impacted, and it's important to understand that these are the protections, and these are unfortunately sometimes the limitations. When you have bubbles of protection that unfortunately can leave people behind. For example, the city of Grand Rapids, Kentwood, and Wyoming, who are all close to each other, have several local fair housing ordinances within the three. Outside communities immediately ringing around that core central area don't have additional protections. So that kind of illustrates a barrier there. Steve?
Yeah, this is a quick summary of fair housing, residential and commercial properties. as we talk further, we're going to see under the Fair Housing Act, it's limited to residential dwellings, and Liz will go through that quite a bit. But the bedrock fair housing laws, the Civil Rights Acts of 1866 and 70, they're collected as 42 U.S.C. sections 1981 and 1982. 1982 expressly covers housing, but it applies to all residential and commercial properties, and the protected class categories are there: race, color, ancestry, ethnic characteristics, and alien status. It has none of the exceptions that you find in the Fair Housing Act or Elliott Larson Civil Rights Act or Person with Disabilities Civil Rights Act. So there are no exemptions under 1981, 1982, and primarily a race discrimination statute. But that is the bedrock one. It's post-civil rights or post-13th Amendment legislation. It was not used for about 100 years because it wasn't thought that it reached purely private housing transaction, and the Supreme Court in 1968 says that it does reach purely private housing transactions. And an Equal Credit Opportunity Act, again, covers residential and commercial. What's significant about it there, it does have receipt of income under any public assistance program, meaning that source of income. So there is source of income at the federal level, but that's only for lending. If it works fine in lending, you think it should work fine in other areas as well. Hopefully it will get adopted at some point, either at the state or national level. And Elliott Larson adds marital status and age, which makes it a little bit different than the Fair Housing Act and the Michigan Person with Disabilities Civil Rights Act. Again, these cover residential and commercial. So when we talk about parts that aren't dwellings, well, it's not going to be covered under the Fair Housing Act, but it will be covered under these other laws.
So this is why we give out our contact information so that we can help navigate some of these pieces and parts, because this is complicated. And as I started, remember, I said there are gray areas and navigating some of this could be part of that. I do want to know Allison has been putting links in the chat, and she did point out that Micah is providing a webinar on HUD's Equal Access Rule and Practice next week. So check out that link in the chat to sign up for that great training. So as we've kind of laid the foundation for, the Fair Housing Act does have a definition of a dwelling. It's pretty broad: any building, structure, or portion thereof, which is occupied as or designed or intended for occupancy as a residence by one or more families, and any vacant land which is offered for sale or lease for this construction or location thereon of any such building, structure, or portion thereof. One thing I want to mention, if you're aware of projects coming online to provide affordable housing or meet some of the housing needs that we are identifying, if there's community resistance regarding who is going to be housed there, if it's tied to a protected class, there's a fair housing argument that can be made that might be helpful in moving that project forward. So again, another kind of thing to listen for. We've seen projects turned down because they were specifically designed to house persons with a specific type of disability, for example. So the zoning and planning conversation is all about who's going to live there. And you can, unfortunately, as a matter of public record, find some really negative statements and assumptions and stereotypes about that population. So thankfully, we do have a broader definition. A dwelling can include homeless shelters, nursing homes, group homes, rehabilitative centers. Depends on the anticipated length of stay, so it might be a case-by-case evaluation. On the other hand, it does not extend to include hotels, motels, hospitals, and jails. These places, as Steve has said, might be subject to other federal and state civil rights laws, though. HUD has relied on kind of this list here as a multiple factor analysis for determining whether a shelter is covered under the Fair Housing Act. This is a fairly common question, and the answer is it depends on what is the model, what's the length of stay, what's the rental rate for the unit, how is it calculated, what are the terms and length of occupancy, is there a lease in place, other written agreement, what type of living does it offer, what kind of amenities are there, including, you know, kitchen for cooking, how is it marketed, what's the purpose of the property, can the resident expect to return to the property, and whether or not that person has anywhere else to which to return are all factors in terms of establishing whether a shelter might be covered. Some of the gaps and limits, I know there's a lot more than this, but I just wanted to throw out a few that we want to acknowledge. You know, there's no protections for rental history or housing status. This is a question I've been getting more and more. You know, how can the price go up so high? How can these increases be so huge? Why does someone's rental history from 20 years ago still matter? These are not protected classes under fair housing law. They're very timely topics. Whether or not someone is housed, housing status is not a protected class. There's no protection for those having current illegal use of or addiction to a controlled substance. If they've been found guilty of the illegal manufacture or distribution of a controlled substance, so if they've been making or selling drugs that are illegal under federal law, that group is left out. There's limited protections for victims of domestic violence. We'll talk a little bit more about that in detail. We are seeing some proposed legislature here in Michigan. Again, these are not law yet, but bills have been brought forward in some cases multiple times that would add sexual orientation and gender identity officially under state law, race inclusive of hair texture and protective hairstyles, otherwise known as a Crown Act. And then a bill introduced last November specific to protecting victims of domestic violence, sexual assault, or stalking. All of these bills have been sent to committee. If they do move forward, of course, we will work with all of our partners to push that information out, but these are not existing protections, but they've been proposed. And as I said, sometimes multiple times in my 20+ year history working in and around fair housing. Other gaps and limits, local fair housing protections, as I mentioned already, they're naturally limited to the boundary of the municipality, which can leave gaps in coverage. For example, I mentioned Grand Rapids, Kentwood, and Wyoming have source of income protections within their local fair housing ordinances, which are not the strongest and are hard to enforce. But someone with a voucher, in theory, who's denied housing simply because they have a Section 8 or housing choice or other type of voucher within those cities, could go to those city governments and file a complaint. If they wanted to live in an outlying area of Kent County, as I remember specifically talking to a woman who had 3 children, and as a Black mother, she was very concerned about raising her kids in the city, and she had a rural upbringing and she wanted the same, but she could not convince any landlords to work with her to accept that voucher. This was before the type of market that we're facing now, where voucher holders really get priced out very quickly. Unfortunately, fair housing laws don't necessarily address equally poor treatment of tenants or residents. How can we prove discrimination if they're being equally treated badly, whether they're a person with a disability, a family with kids? There are other laws that can be triggered, but these are things that can feel unfair, but are not in fact necessarily covered under fair housing law. Local rent control ordinances are prohibited under Michigan law. So housing providers can set that income standard at 3 times or even 4 times the rental rate. And this certainly leaves behind a population of voucher holders or people on disability or Social Security income, of course. So lots of barriers that were existing before the pandemic and are only being, I think, exacerbated by our circumstances now. Steve?
Yeah, there's a couple of them been significant developments when it comes to sex discrimination. The Vostok versus Clayton County, that's a case that came before the Supreme Court under Title VII, and the Supreme Court held that sexual orientation and gender identity are included under sex, under this, the category sex under Title VII. So the word sex is interpreted to include sexual orientation and gender identity. President Biden issued Executive Order 13988, which recognized sex discrimination to include sexual orientation and gender identity. HUD did a memo implementing it. But even prior to this, there are several fair housing cases, you see them cited at the bottom there, where courts were already holding that discrimination against people based on transgender status, sexual orientation, would be covered under fair housing. And so that has been the law. But again, the Supreme Court's ruling, even though it's under Title VII, I don't really see a way to distinguish that when it comes to fair housing. So probably, in all likelihood, courts will continue to, under the Fair Housing Act, interpret sex, protected class category sex, to include sexual orientation, gender identity, and transgender status. And here's what's going on in Michigan, kind of unique. The plaintiffs refused to provide services to customers. There's either same-sex couple or transgender person. The customers filed a complaint with the Michigan Department of Civil Rights. The Michigan Department of Civil Rights investigated it. And then at that point, the defendant appealed it to the Michigan Court of Claims. The Michigan Court of Claims then issued 3 rulings. Under gender identity, it followed Bostock, held that Elliott Larson applies to discrimination based on gender identity. On sexual orientation, they said they were bound by a Michigan Civil Rights Commission interpretive statement, which holds that sexual orientation was not prohibited under Elliott Larson Civil Rights Act. And then the Court of Claims deferred the ruling on the free exercise First Amendment claims. And in any of these cases, there is, I wanted the name of it, escapes my mind, but I do know it, Hoffius. There's a Michigan Supreme Court which recognized First Amendment free exercise defense to a fair housing claim. That would have to be proven. So anyways, the Michigan Department of Civil Rights, rather than appeal from the Court of Claims to the Court of Appeals, sought direct review in the Michigan Supreme Court. The Michigan Supreme Court granted it, and they're going to decide whether prohibition on discrimination because of sex in Elliott Larson includes sexual orientation. So they're going to only review that aspect of it. They had arguments earlier in March. So I would think that there will be a decision in a couple months. My gut feeling, I mean, you can never predict what courts will do. This time, I would take it like the Supreme Court. I believe that they will see that because of sex will include other categories. And I would think that that would still be persuasive as well when it comes to Elliott Larson. The section of Elliott Larson that deals with housing is going to be interpreted the same way the portion of the Elliott Larson Civil Rights Act applies to employment discrimination. Treated as covered, even though it's not formally in the statute.
So we'll hopefully get further clarity and something to point to. We shall see. So moving into criminal background screening, there's 2 sets of guidance, and we've got a very comprehensive listing on our website. HUD has these materials out as well. We're happy to provide links. I did see a comment, people are interested in slides, so I think I can work with you, Steve, on that and come up with at least most of the slides that we would share in some form or another. We'll follow up on that.
I think too, some of the slides like here, the guidance, it's linked. So I think if they get the slides, they'll have the link to the.
And make sure, I've got to make sure to do it in a way that the links work because I've done that before. Send it out and the links are dead. I will work on that.
The ones I looked at seemed to work. I mean, it seemed to work. Maybe when it's, transmitted,
okay, good.
Maybe they get lost.
Yeah, once I make the PDF, yep.
The PDF may do it.
Yeah, but there is a way to do it and we will get that information out because we did put in a lot of great links. So public housing agencies or PHAs have a separate set of guidance dating back to 2015. HUD issued guidance in 2016 that's more general for the private housing market to help set forward some standards about processing or evaluating applicants with a criminal record. It's still not a protected class. There's 2 exceptions here. The cities of Detroit and Jackson have some local ordinances that have added an element of protection related to having a criminal record, but generally everywhere else it is not protected. I'm appreciative of the fact that HUD addressed it at that point, and they are going to circle back to this with this new team at HUD, because nearly 1/3 of the US adults have a criminal record of some sort, which of course can interfere with housing and employment and beyond. So last summer, the HUD Secretary, Marcia Fudge, made an announcement. They are following up on the 2016 guidance to help private landlords, PHAs, multifamily housing owners look at their applicant screening and tenant selection practices, hopefully putting out some really good and helpful tools that would be consistent with that last set of guidance. So we will look forward to sharing that. I understand that meetings are underway, so it is work is being done. And again, as soon as that's available, we'll push that out. Detroit's got a great webinar, Steve. It's probably you, Steve, right? On renting in Detroit. Is that are you presenting?
No, there was Lisa Kent from Detroit's Department of Civil Rights, Inclusion and Opportunity.
Oh, great. Okay.
Spoke. Chewy Kariga,
great.
General Counsel for Detroit NAACP. Nice. They have a free expungement service. I spoke a little bit on the HUD OGC guidance as well, but it's really quite a bit of information in there.
Great. What a great resource. Thank you.
Well, back up. I think your resource is great. The fact sheet is very good.
Okay.
No, it's off the topic we're not there yet, but I think your fact sheet on occupancy standards is outstanding as well. So.
Oh, thank you. We do try to make some hands-on tools where we can. Again, just trying to help people comply and avoid cases. I mean, we can't ever undo the experience and the harm of experiencing housing discrimination. So where possible, we really do try to focus on helping people with best practices on the front end to avoid that from happening. The 2016 criminal background screening did not have a detachable, this is how you do your policy. This is a discrimination-free example of how to do this. That's not something that HUD ever typically issues, but it did have some hard takeaways that have really been utilized in the intervening years to make some progress, really around pushing back against blanket bans, for example, properties that had no felony standards. Those cases have a number of cases, I'll talk about one, have been brought forward to successfully challenge that as racially discriminatory. They're very clear that conviction records are the only type of records that should be used, not using arrest records. The only group that it's clear about prohibiting is, again, those that have been convicted of illegal drug making or selling. It does recommend that policies focus on the nature and severity of the individual's conviction and consider the amount of time that has passed, as well as conduct an individualized assessment. So if there's providers out there who are not putting in this legwork, haven't updated their policies, there's an opportunity maybe for some education, advocacy, and potentially maybe a complaint. This is a case out of Virginia, Sterling Glen Apartments. This was a lawsuit filed in Chesterfield County. In this county where the case was filed, a Black resident is 3 times more likely than a white resident to have a felony or misdemeanor conviction. So they charged that their policies were racially discriminatory under this 2016 HUD guidance. They rejected applicants with criminal backgrounds and had a blanket ban. They promoted this information widely, that this was a written policy barring applicants. So there's evidence right there of what they were doing. They didn't allow any exceptions. They didn't do any of that individualized assessment. They didn't look at whether they had been a good tenant elsewhere. So pretty much drew a very hard line here. As a part of the settlement, they've revamped their policy. It's available. We can share that with anybody who's interested. It really does look at specific categories of offenses using a 5-year look back period. We've seen, lifetime bans, 50 years, 75 years, 25 years, you name it. So a 5-year look back is pretty reasonable here. They're kind of clarifying on what they're looking for and how they'll treat people, for example, who are on probation or parole. And they're doing that individualized consideration, which I think is really key. They're taking into account whether they've got a good rental or employment history. They're looking at the circumstances around the conviction and accepting any proof of rehabilitation efforts. So I think this will largely be cited in the new tools and guidance to come. So I know we're moving quickly, but we've got a lot we want to cover here. So Steve, you want to talk about the OGC guidance here? Yeah,
they have a couple of different policies. This is a sample that it's in reference in the OGC guidance of a best practices policy of a public housing agency. And it gives some ideas, kind of gives an illustration of what Liz mentioned about the individualized determination. And there's should be a policy when it comes to screening someone for occupancy. There should also be a separate policy, I don't have it here, when you decide whether someone's criminal activity would warrant eviction or terminating the rental relationship. But you can see, especially Part C, well, B has look back periods in that. But these are very, very helpful factors. And like CA, whether the applicant's offense bears relationship to the safety and security of other residents, the level of violence that's involved, length of time since the conviction. I would say too, Detroit's ordinance is way too broad. It said any violent felony, many of the felonies could be, it could go back 20, 30, 40 years. There's no protection under Detroit's fair chance ordinance, just too broad. Length of time since the conviction, the number of convictions that appear. If the applicant is now in recovery for addiction or other influence of drugs at the time of the offense and any rehabilitation effort. So it's an individualized determination. I want to add something else into here as well. If it's a public housing agency in that, there's also a due process requirement. So they have to meet due process requirements, meaning giving people an opportunity to provide records concerning why they're being turned down and give them a reasonable opportunity to address it. So in addition to not only discrimination, there can also be a due process argument on this as well. And so this is an example of how it should work if it's a case by case evaluating whether or not someone is occupied or is qualified to be a tenant or to remain as a tenant. Mm-hmm. Kind of I think the next one, a little flow chart, best practices. And Detroit has this written into their fair chance ordinance. Jackson does the same thing. But first off, they should delay consideration of criminal history until after financial and other qualifications are verified. If not, then it looks like criminal record is being used to screen people out. We saw this, an analogous situation when it came to getting mortgage loans. Of a Black applicant walks in, the response is, we'll have to pull a credit report, see what it looks like before we even start to consider your qualifications. When a white applicant would walk in, well, we'll get the credit report, all of that later. Let me show you the kind of loan programs that we have. Obviously, that looks discriminatory. It's not treating everybody the same. So ideally, look at consideration of delayed consideration of criminal history, just looking at the qualifications in terms of someone's income, their credit, and rental history. Those are the three things that are always relevant, and do it. And then after they make the decision to qualify someone based on that, then obtain record criminal history, only obtain record of a conviction. Like Liz said, exclude arrest records, and then avoid a blanket prohibition and consider all the factors that we mentioned. And then carefully review the HUD guidance, because these have really good guidance in terms of what kind of policies HUD would find acceptable or best practice to follow for screening for criminal activity and seeking to evict based on criminal activity. And just a follow-up what Liz says, the 5-year, for example, not considering something beyond 5 years, that's just not, gee, that's a nice policy to use, whatever. It's grounded on statistics. If people go 4 or 5 years and they don't pick up another felony or misdemeanor, they become very short time. They basically have turned their life around. They're no more likely than the public at large to pick up another case. So it's not necessarily risk, and it really should be just a practical matter. Do you think that someone, if they were allowed to be a tenant, permitted to be a tenant, would really legitimately be a threat or concern? Depending on what the prior record is, if the answer is no, I don't really think they would be, then they should be rented to. It's really that kind of a basis. But if it's a flat one, like no felonies or misdemeanors in the last 10 years, something like that, that's a violation. Someone wrote Joanna wrote, landlords in Detroit are still discriminating based on criminal record. How can this be addressed? You can contact us. It can be filed. We can do a complaint with Detroit's CREO department. We can take a complaint administratively with the Michigan Department of Civil Rights or HUD, or refer it to an attorney and taking it straight into court. So a variety of things, depends on the circumstances. We actually had more criminal record cases earlier, and they seem to have lessened a bit. And I don't know why, because I think it's still going on. Maybe it's better or not, but please report it. I know, from the people that are in this webinar, you have trouble placing people because of their criminal record. It's a problem, but please make the complaint. We cover Wayne, Oakland, Macomb County, all of Detroit. We're available. If it's in other parts of the state, we'll make sure we'll get you connected with the right center to handle that. Fair Housing Center of Southeast and Mid-Michigan has a number of federal court complaints involving criminal record policies. We have some pending. So please report it.
Yes, bring it forward. Okay, this is a very timely topic, and I think really connected to some of the questions that came out of the session last year. So we wanted to spend a little more time looking at source of income protections. As Steve mentioned, there's no national protection for source of income, which means generally across multiple local ordinances that define it generally the same, is that it's legal and verifiable income that should be counted towards household income. This includes vouchers. Unfortunately, a lot of times we'll see local fair housing ordinances that don't even reference, include the word voucher or subsidy. Sometimes we'll see subsidy language used, but essentially this is anything that's not employment. We just see a real bias that housing providers are only looking for employed individuals. There's a lot of conversation about developing workforce housing, which is truly a need across many of the communities in the state, but we want to keep in mind that not everyone has employment-based income. So this is a real gap, of course, and there's been multiple efforts over the years to introduce it at the national level. There's a great ongoing conversation about how this might happen here in Michigan, so I'll talk about that in a second. A growing number of states and municipalities have adopted these ordinances and these protections that generally make that standard known. The challenge is, the enforcement mechanism is not often there or is not very effective at the local level. But it should allow for a household who has alimony, child support, Social Security or disability income, different types of vouchers, other sorts of housing assistance to bring that total to their household income and see if they qualify. Sometimes we'll just see blanket, no Section 8 just written right in an ad, or as soon as somebody calling around with a voucher says, I've got a voucher, they're, hung up on, or they don't ever get a phone call back, or they're just blatantly told we don't accept that. Some housing providers rely on a policy of not accepting money from a third-party source in order to refuse accepting vouchers. This makes it very, very challenging. And I know a lot of programs and partners on the call today are always actively looking to recruit landlords that will work with voucher holders and others who are utilizing subsidies. The local ordinances can be very unclear or very limited in terms of enforcement. And of course, the nature of the market right now is that they're priced so far above that voucher holders don't qualify right out of the gate. MICA is organizing a group. They've named themselves the Coalition for Expanding Housing Access, but they were the SOI group for a long time. So if you're interested in further information or engaging with that group, I think they're meeting every other week still and talking about how can we add this protection either to Michigan tenant landlord law or possibly as a civil rights protection under Michigan's Elliott-Larsen Civil Rights Act, or ELCRA. If we don't explain an acronym, please let us know. Try to be really careful about that and not using lingo without sharing what it means. At our Fair Housing Center, we've worked with a number of housing providers and landlords who have contacted us because their insurance companies are trying to charge a higher amount or refusing to cover properties that house protected populations, including, for example, Section 8 voucher holders or housing choice voucher holders. So we've been trying to push guidance up through the state insurance agencies and some of the monitoring groups to let them know about fair housing protections. And that's something that we can assist with, as could any other fair housing center.
Liz, can we go back to your last slide? Yeah. On the last point, if it's shown statistically that a high percentage of residents or voucher holders are Black or other disabled or other protected group, that can be challenged as disparate impact, discrimination as disparate impact. And there has been a case where that's been asserted successfully. So sometimes it's kind of a backdoor way of excluding Black tenants or Black occupants by turning down Section 8.
Absolutely. And then, it feels like there was a trend for a long time of new management taking over properties that had housed voucher holders for a long time. They come in, change the policy, push folks out. So it'd be really beneficial to see some statewide or broader protection that would really allow for true choice, where people don't feel like they're limited to a small geographic area where they're still trying to plead their case to use these resources. And I have to say, anecdotally, I've talked to a number of housing providers who feel like they were able to be a little bit more stable during the pandemic because their income included voucher holders. They didn't have tenants universally across the board impacted by job loss or wage cuts throughout the pandemic. That wasn't their total portfolio. They were engaging with some of these programs. So I'm always a proponent of the business sense of accepting guaranteed income. I work for a nonprofit and I work very hard on grants and fundraising to make sure that I'm paid for and my staff is paid for. So I think it's really important to pay attention to that. Allison put the Lisa Chapman's email in the chat. So if you're interested, please grab that. You can also copy information from the chat or save the chat if you use the 3 little dots at the bottom. Just a little Zoom tip there.
Yeah, Crystal's point in the chat is good. For fair market rates are too low in their counties. That's true. They have to work with the housing agencies and with HUD to address that. But that is a major problem because we can have source of income protection all day long, but if the market rates are too high, it's not going to work. Luke, I'm going to get to yours when it comes to permissible applicant inquiry questions.
That's a great question, Luke.
Yeah, that's a good one. That deserves a good answer. And then Anonymous asked, discriminatory landlord to put in their ad, they will not accept Mr. housing vouchers. Are they allowed to do it? They're allowed to do it unless it's covered under your, as local, Michigan, we don't have state coverage on it. So unless it's in a local ordinance, you couldn't really challenge that. The only thing would be if it's being used to exclude, for example, we've had housing providers say they won't accept Detroit vouchers. It was 97 or 98.7% or something. It was a very high percent, I think 98.7% of the voucher holders coming out of the Detroit Housing Commission were Black. So that's a problem there. But anyways,
it's something that could be reported to a local fair housing center for follow-up investigation. Would I be right on that?
Yes, absolutely.
I work on the education side and Steve does both. So I think our team would welcome information about that ad because it would be a possibility to evaluate how would they treat a white voucher holder versus a Black voucher holder, et cetera.
I just feel like I felt that about sex was going to be interpreted to include sexual orientation, gender identity, transgender status. I feel the same thing with source of income. It's just, to me, it's a matter of time it's going to be adopted. Professor Schwem has an article on source of income. He estimates that, roughly speaking, throughout the United States, almost half of the properties, rental properties, are covered under source of income protection. We're just not there yet in our state. And it's kind of surprising. Michigan is not more of a leader on this. But again, there is no source of income protection under the Fair Housing Act. It is under Equal Credit Opportunity Act, but that's only for lending. But that's it. At the state level, it's up to 20 states, including District of Columbia. Within the 20, though, 2 have limited or no protections for voucher holders, one in the statute, another one is in a court decision. We don't have anything in Michigan. At the county and local level at the bottom, Detroit has public benefit status, and it doesn't get listed from groups that identify source of income, but public benefit status is really the same thing. I'd argue it's even broader than source of income, but it's not using the magic word, so people don't pick up Detroit as covering it. So it is covered in Detroit, as well as Ann Arbor, East Lansing, Grand Rapids. Through interpretation, it's not enforced as to vouchers. It's enforced, though, in Holland, Jackson, Kalamazoo, Kentwood, Lansing, and Wyoming. We've, through Oakland County, Charlie Cavell is Oakland County Commissioner. He's been leading getting source of income adopted, although Oakland County can't directly regulate it, that they've been really urging source of income protection. Our office has written a draft source of income statute or ordinance, which a number has been provided. It's been adopted now in Royal Oak Township, Ferndale, and Oak Park, under consideration in Madison Heights. And I think I should have put probably Troy in there as well, both leading to get more and more adopted. One thing that comes up, which is a concern about exemptions, there's a realtor group, not going to name them, insisted that the fair housing exemptions apply. But that guts it. For example, if a mom and pop have a single family home, if that's their only home in addition to their home that they live in, then they would be exempt from having to rent to someone with, on a voucher holder, because they'd have the single family exemption. So things of that nature, the exemptions make a really big deal. However, it would be good at least to have apartment complexes than having to rent to people with vouchers. All the parade of horribles that will happen if source of income gets adopted haven't occurred in the 20 states that have adopted it. They just haven't. I just think there's more concern about it than needs to be. It should not be that big of a deal. Oak Park. Yeah, the city manager in Oak Park called it a, quote, no-brainer in terms of adopting source of income. He recommended it to city council and they adopted it.
Oh, wow.
So let's hope, and again, the idea is to build it up at the grassroots, city, villages, and township level, and then eventually to have it formally adopted by the state. And much as we laud the Fair Housing Act, the Fair Housing Act was passed after many states had begun to adopt fair housing legislation. And Congress came a little bit late to the table on that one. And I think the Michigan legislature is probably starting to come late to the table on this as well. Oh, real quick too, MISTA has a first statewide housing plan, which kind of relates to this. So it tells you that there's some support with MISTA, and they note that voucher holders are having difficulty locating rental units. The estimates are what? 2/3 maybe have trouble finding housing. It's just way too high, especially when we have a problem with affordable housing, especially when we have an eviction crisis and all the effects that happen to children and their education, and on and on and on it goes. We should be doing anything we can do to increase the supply of affordable housing. Vouchers help achieve that goal.
I think we had a quick question, a clarifying question. So source of income isn't protected in mortgage lending. I thought it was, and I want to say it is.
Yes, the Equal Credit Opportunity Act.
Yes. Okay.
Again, it's not going to say source of income. It's going to individuals receipt of public assistance. I get the language. I can pull that up.
There's so many different ways to say the same thing based on all these different laws and layers. So it's there.
You just don't see it. Often people, when they go to get mortgage financing, have employment income typically, but it can be used. I asserted in one situation, kind of illustrated, this was a U of M graduate student in sociology. She received $8,000 every 3 or 4 months. I think every 4 months. Some of that could be used toward housing. She also had food stamps, and she was turned down on a loss mitigation program. She lived in Detroit, and basically a foreclosure case. So I asserted that as a counter complaint, violation of Detroit's ordinance on public benefit status, counting her student aid and her food stamps as public assistance that therefore should have been counted and taken into consideration. If that had been taken into consideration, she could have got the loss mitigation program and avoided the foreclosure. So that's kind of how you can use that. But source of income would fit under source of income as well. Again, it should be very, very broad. Any kind of assistance that someone can use toward their housing is covered under source of income. It's just like it sounds. You can't discriminate against someone based on where their money for housing comes from. That's the whole idea.
Legal and verifiable.
Just common sense. Like, well, no, I don't want to rent you because I don't like where the rent money came from. If you phrase it that way, it seems very unreasonable to turn somebody down.
I like.
Do you care where the money is? It shouldn't matter to someone where the money came from.
Right.
I'd say no.
Yeah. Allison posted the statewide housing plan will be released at the Building Michigan Communities Conference in early May, and that is open for registration. You can also get a sneak peek of that in one of our workshops at our April 28th event, which is next week. Very briefly, a couple of the questions raised at the end of the session last year were about kind of targeted housing and program-based housing. And I just want to say, as we actually just covered briefly, was that most housing in Michigan is going to be covered by the Federal Fair Housing Act, Michigan's Elliott Larson Civil Rights Act, or Persons with Disabilities Civil Rights Act. Programs tied to housing should not discriminate unlawfully, so they need to be equally aware of all the coverages that we have talked about. Now, of course, then there may be some exemptions that I just want to highlight briefly. There are some shared living or gender requirements that can be put in place. It's really, the language is still female seeking female roommate, male seeking male roommate, kind of predating the time where most people are just looking for someone who will be compatible and pay the rent on time and be responsible. But this is something that can come into play when there's shared living spaces like bathrooms, bedrooms, and kitchens. The Fair Housing Act does not prohibit a housing provider from limiting housing to persons with a specific disability. But if federal financial assistance is provided, that triggers coverage of Section 504 of the 1973 Rehabilitation Act, which would prohibit then disability-specific housing funded with those dollars. So those types of programs, it's important to analyze those, look at the sources of funding, look at what coverage of which laws would be triggered in order to set this up. This is something a lot of communities are considering as they're looking at meeting the identified needs. There's a lot of really great housing conversations going on, but we really want to make sure that any housing developed, especially if there's a program, you know, that's a part of it, that it's developed with fair housing and equal opportunity in mind. As we've already discussed, age is a protected class here in Michigan. The only exception, of course, is the HOPA exception, which I mentioned is 55 and older and 62 and older. There's some very basic thresholds here. It's supposed to be organized, designed, and run with the intention to be occupied by elderly persons under federal, state, or local government program. 100% of the residents are 62 and older, or there's at least one person 55 and older, and at least 80% of the occupied units. And again, it's intended to be housing for older persons. So this is one small exemption for older adults. But we do tend to see all kinds of bylaws and preferences and targeted marketing and advertising with all kinds of different age restrictions that don't align with these two. So that would bear further scrutiny. Steve?
Sorry. So federal financial assistance, often the difficulty, I think Liz does training on this as well, but to identify what constitutes federal financial assistance before Section 504 and other types of federal laws apply. It includes any state and political subdivisions automatically because states receive federal funds, and going with those federal funds constitutes federal financial assistance. Once you receive any financial assistance, federal financial assistance, it obligates your whole municipality or organization, then will be covered. Public housing and housing choice vouchers are covered. Any type of those type of programs, HUD-funded nonprofit developer of low-income housing, CDBG home funds, and so forth. It's unclear with the low-income tax credit, property, LIHTC properties. Treasury Department says it's not covered, but courts are split. It really hasn't been answered. I like to argue that it would be. I've seen people concede that it's not. I think it's an open question, and if I have the case site there if someone would like to take a look at it. But there is no coverage for a private landlord who accepts vouchers. That's one that's not covered. But it's very, very important to know whether Section 504 or VAWA or other kind of protections apply. You have to establish federal financial assistance.
Mm-hmm.
One quick thing on Section 504, it just has that broad statement which says no otherwise qualified individuals with a disability solely by reason of disability be excluded from participation in a program or activity or service receiving federal financial assistance. And that applies as well. It does require or permits reasonable, it defines the regulations for 504 defined reasonable accommodation in a way that includes reasonable modifications. So it's very, very important to know in any type of housing if there's federal financial assistance involved.
And this is something that fair housing centers can help with in terms of advocating for accommodations or modifications, doing some of that legwork and research. So we're moving through a lot. So feel free to keep using the Q&A. I do want to say, Allison is so great. Both Steve and I will be presenting at different workshops at the BMCC, the Building Michigan Communities Conference, and then we're doing one together. So we're continuing our show. So yes, really solid programming available there, and fair housing is included, which I appreciate. So we briefly, well, actually, we pretty much covered the fact that we have this extension of protection under the existing gender protections from the 70s under the Federal Fair Housing Act. Steve really reviewed these in detail. So you've got that information. I'm happy to send any of these documents or pieces of guidance directly out. Michigan was a bit of ahead of the curve of the federal government because the Civil Rights Commission had already started interpreting and accepting complaints based on sexual orientation or gender identity discrimination in May of 2018. So that protection is there, and we may see these officially adopted as protected classes here in the state or potentially even at the federal level. So essentially gives the enforcement ability to HUD to look back. From February of 2021, they went back and said, we're going to look at all the cases in the last 12 months, actually, and determine if these are cases that would be brought forward under this memo issued by the HUD Secretary, Janine Warden. Do I have that right? Yeah. I always call her Secretary Warden, so I have to stop and think of what her name is. So that they've really been taking this on very seriously, and we're willing to look back within their purview of time and reevaluate gender cases to see if they could be addressed within that window. We also discussed the equal access rule. And again, it's really something that fair housing centers can do, especially from the advocacy point of view. Our fair housing center will help housing providers. Steve, I think you do to a point also help with folks who are interested in compliance, help them understand what laws apply so that they can ensure that the actions that they take are hopefully in good compliance with fair housing. But this is a homework assignment. Getting to know how the program is funded. If you're working somewhere and you don't know, you got to know so you know which protections and guidance is triggered. So a sample listing of here of properties that would be covered by the equal access rule, and the homework is, what are the funding sources? What are those requirements? And then make sure that either through advocacy or looking for compliance, you really do this homework and have that established, and then make the determination about the action to take under fair housing. A couple of examples of situations that would violate the equal access rule: a gay man being evicted because his landlord believes he will infect other tenants with HIV/AIDS. This is also covered under disability protections at the federal level. So that was something that we could move forward. A transgender woman being asked by the owner of an apartment building not to dress in women's clothing in common areas of the property. This violates sex discrimination. Property manager refusing to rent an apartment to a prospective tenant who is transgender. The denial is based on gender stereotypes. That would be illegal. So this is something that I think we'll start to see a lot more of. These were all based on real incidences, and it could be very frustrating in my early years. Hearing from people experiencing this type of discrimination when there wasn't a lot of traction, or there was very limited coverage in terms of who was able to file complaints on these bases. So we were using disability and gender protections as best we could, but now we've got a bigger set of tools in the toolbox.
We could back up for a second.
Yeah.
They should be careful. There's a kind of obscure provision in the Fair Housing Act which says it doesn't apply to transvestites. So I wouldn't make a point about the clothing as much as talking more about gender stereotypes and so forth. A recent case, we had a transgender female. People were throwing a lot of garbage in that by her front door. So she put a camera up there. And DTE was called out to do some service at the home, and the maintenance person for the management company there stopped the DTE worker and said, in talking about the person being transgender and whether or not you really want to go into the home and so forth, really discouraging someone from DTE from actually doing the work at the home. And there's a claim as well that the other maintenance requests really weren't being performed timely or weren't being performed at all. So again, the camera didn't go up for that reason, but sure enough, it captured it. So it's a good training video, I'll put it that way. But it does go on. Obviously, it just goes on. But again, not only just the housing provider or the maintenance, people, but the fact that other people in the community, the harassment and that was going on is quite disturbing.
Yeah, we had a client who rented a first floor business space, commercial space, and then lived above in the private, apartment above. And when that person transitioned from male to female, the owner, the landlord, went in and changed the locks on both places. So she lost both business and housing with that step. So these are certainly things that I think we'll continue to see more from. We're also hosting a workshop on gender equality at our event next week, if you're interested. So got to move into persons with disabilities. This is our biggest case area. So we wanted to spend a little more time on this, even though we have done a lot of education on it. It's important to understand that there is a definition of being a person with a disability under law. It's broadly defined, which can be very inclusive of a lot of people who are maybe having a mental disability, physical disability, or some combination of both. The legal definition here, a physical or mental impairment that limits a major life activity. It could be a record of having such an impairment, or it could be regarded as having such an impairment. So that assumption or applying a stereotype or a filter to a population. So very broadly defined and very inclusive definition. The Major life activity could include physical, mental, social activities, going to work, sleeping, walking, bathing, breathing, eating, hearing, driving, etc. So those are essentially two standards that would trigger this coverage under fair housing. So it could be inclusive of all of these examples here: cerebral palsy, cancer. We talked about a situation with HIV, diabetes, emotional illness, drug addiction, not including current use, recovering from alcoholism, visual and speech impairments, etc. There's two opportunities which we briefly talked about with Section 504, modifications and accommodations. We have lots of tools and information available on our website, and this is a very high interest topic. There's a lot of our caseload that is a failure to allow for accommodations for people with disabilities. Smaller number of the modifications, which would be like grab bars or changing out the doorknob here that you see on the right of the screen. That used to be a round door knob that you would grip and turn, and we were able to advocate to get that modified to a lever style handle. Accommodations would be an example of assigning an accessible parking spot for an individual's use, or having an assistance animal, which we will talk more about in a moment. I did want to talk a little bit more, because we have focused a lot on who is covered in our past sessions. Again, anybody who is currently using illegal drugs is not considered a person with a disability under the Fair Housing Act. Anyone convicted for the illegal manufacture or distribution of a controlled substance is not included. Anyone whose tenancy would constitute a direct threat to the health or safety of others is not covered, but that may be subject to an accommodation request. Anyone whose tenancy would result in substantial physical damage to the property of others, not covered. I'm drawing this information from the Department of Justice and HUD joint statement on reasonable accommodations. There's another document that talks about modifications. These are actually really helpful, fairly reader-friendly documents. They're Q&A format. So I wanted to share one question here about the Act protecting juvenile offenders, sex offenders, persons who illegally use controlled substances, and persons with disabilities who might pose a significant danger. So they kind of clarify juvenile offenders and sex offenders are not persons with disabilities covered by the Act. If somebody is recovering from substance abuse, they would be covered, but if they're actively using, they are not. And then there's an assessment process that needs to be evaluated in terms of evaluating whether or not someone with a disability is a direct threat by being a tenant. Are they going to impact the health and safety of others, or would there be substantial physical damage to the property as a result of this person? So this could trigger an accommodation request. And there's a great case example that I'll go through in a moment. But essentially, it's a pause. You know, we need to gather information. This is true of any accommodation or modification request. It's an opportunity to look at what laws are triggered, what possibilities might be on the table, given what the person is asking for, given the type of housing, given the landscape of the housing. So it's an individualized assessment that is based on reliable objective evidence. That's really important. The assessment should look at the nature and duration and severity of the risk of injury, the probability that injury will actually occur, and whether or not there are any accommodations that would eliminate the direct threat that having this person as a tenant would pose. So factors that might come into play is whether or not the individual has received any intervening treatment or medication that is focusing on or will help eliminate that direct threat, so that there's a significant risk of substantial harm there that's being mitigated by treatment or medication. This is then something that would be part of an interactive process where that information could be obtained. You know, we want to make sure that the information that's gathered and used is factual information, and that it is creates reliable objective evidence that the housing provider can rely on to address this potential direct threat. So this example comes from, again, that joint statement. I thought this was helpful. We've had a number of cases very similar to this, actually. So we have a tenant who's arrested for threatening his neighbor while brandishing a baseball bat, and this is James. The lease agreement naturally prohibits threatening violence against other residents. The manager investigates, as would be required, and learns that James threatened the other residents with physical violence and had to be restrained physically by other neighbors to keep him from acting on the threat. Following standard practice and strictly enforcing their no threats policy, the manager issues a 30-day notice to quit, which starts the eviction process. The response from James' attorney is that he explains there's a psychiatric disability that caused James to be physically violent when he stops taking his prescribed medication. The attorney suggests that his client will not pose a direct threat to others if proper safeguards are taken. So the attorney asks for a reasonable accommodation from the manager to grant James an exception to their no threats policy based on this disability. The manager will only need to grant the reasonable accommodation if the attorney can provide, again, that satisfactory assurance, those facts, that James will receive appropriate counseling and periodic medication monitoring so he's no longer posing this direct threat during the tenancy. In this situation, in this example, the attorney consults with James, and James responds that he's unwilling to receive counseling or submit to any type of periodic monitoring to make sure he's back on the prescribed medication. So according to HUD, this rental manager here may go forward with the eviction proceeding because James is not doing anything to mitigate the direct threat that he is posing to the health and safety of other residents. So this is a little bit more of a nuanced look into where the protections can go and where they stop. Steve?
Yeah, just to show kind of the background for disability protections. Congress' first step in disability rights was Section 504 of the Rehabilitation Act. And when that was being debated in the House report, they were considering whether to list specific diseases and conditions that can constitute physical or mental impairments. But they were concerned about any kind of a comprehensive list because there can be diseases or afflictions that were not even discovered or prevalent at the time it was adopted. So the Rehabilitation Act did not come up with a specific definition of what that would be. Then you move forward to the Fair Housing Amendment when it got amended to add disability and familial status in 1988. When disability got added as a protected class, Congress at that time was concerned with HIV and AIDS virus. And there was an amendment to exclude people with HIV or AIDS virus from the definition of handicap. The common, I mean, the more modern term is disability. But they would have excluded persons from handicap protection if they had an infectious, contagious, or communicable disease, whether or not it caused a physical or mental impairment. That amendment got defeated. So therefore, there's not a specific listing in the Fair Housing Act. It's, again, more generalized language, just like you see in Section 504 of the Rehabilitation Act. And you see the wisdom of that now when we're dealing with COVID. So it ended up being way, so probably COVID is something that would be covered.
And we've seen some initial guidance under Section 504 from HUD heading in that direction for long COVID is what I've seen, long COVID only.
Yeah. Now, there's nothing in the Fair Housing Act which talks about requests for medical information. It's really not stated in there, but there is language in the House report. Congress wrote, owners of housing do not have the right to, this is a House report in their report, owners of housing do not have the right to ask prospective tenants or buyers blanket questions about their disabilities. So HUD took that language, again, it's not in the Fair Housing Act or the 88 amendments, but it's in the House report, and HUD used that and drafted their regulation to implement that. And here's what it says. There's, I say 100.202, I think is the section, 24 CFR 100.202, if I'm not mistaken. There's impermissible inquiries and permitted inquiries. You can ask, it's not permitted to ask whether the applicant has a disability or the nature or severity of the disability. That is a per se violation that's viewed as discouraging someone from renting and be a violation of 804C. There are permitted inquiries, and they're very, very limited. They can be asked about the ability to meet the requirements of ownership or occupancy, meaning income credit, rental history, and so forth. Provided that's asked of all applicants. It's just asked as people with disability, whatever, or people with particular race or background, then it wouldn't be permitted. Second, they can ask whether the person is qualified for a dwelling available only to persons with disabilities or persons with a particular type of disability. That is one that can be preferred. Why? Because people without disabilities or people without a particular type of disability are not protected. That's the only category. And then you can ask, Liz has mentioned this several times, and it's in the HUD regulation as well. They can be asked if they're a current illegal abuser or addict of a controlled substance, or that they've been convicted of illegal manufacture, distribution of a controlled substance. That would be considered, Congress would consider that person a drug dealer, or HUD considers that person a drug dealer. They're not covered. If they're an illegal abuser or addict, they're not covered. If they're alcoholic, right, drinking is legal. They have alcoholism is counted as a disability, so that would be fine. But these are the very, very narrow range. Luke, go back finally to Luke's question. How are agencies or COCs able to target historically marginalized communities? And he lists for housing preference, Black, Brown communities, LGBTQ+ community, and so forth, without violating the fair housing laws. Well, this answers the question. First, people with disabilities, yes, you can prefer them if the dwelling is there. It could be a barrier-free unit or various features of it, which would be, better serve persons with disabilities, a person with this type of disability. You can have an applicant jump the line in order to get that unit. That's perfectly fine. But any other group, for example, Black and Brown communities, if you're favoring Black and Brown communities, you're disfavoring non-Black and Brown communities. If you're favoring LGBTQ+, you're disfavoring heterosexuals or other groups as well. That would be illegal. So the way it would be, if you want to do that without violating the fair housing law, then you could do maybe programs available for people of low income or certain things like that. You can give a preference because that's a non-discriminatory type preference. But if it's done overtly like that, except as to persons with disabilities, it would be illegal, and it could be challenged as violating fair housing laws. So get back to, I'll just throw it out there, sexual orientation. With sexual orientation that previously, when it was not covered, you could advertise a gay-friendly building because sexual orientation, heterosexuality was not a protected class. Now that sexual orientation is covered, then it would be discriminatory to favor or disfavor any group based on their sexual orientation, whatever it is. So that's sort of the way that it works. So you wouldn't want to do it directly like that. So just, you find a creative way to do it. You say, well, we'll advertise in, publications that certain protected groups like to use. Probably it's okay, but that even comes into a gray area as well, because your advertising should be broad and inclusive. Yeah. So that can become questionable as well. So appreciate the question, appreciate the sentiment. Yeah. But again, you have to be very, very careful because you're giving preference to protected groups, and the opposite group or contrasting group is now being dispreferred, if that's a way to put it. Yeah, that's a red flag. That's what discrimination is. Yes. Yeah. Yeah. So it requires that creative approach and consulting with fair housing experts. I would say we're hearing from a lot of groups and parties that are looking to meet these gaps in housing. But sometimes there's a reason why these programs and housing targeted groups don't exist, is because it would violate fair housing laws. So we do encourage, that's not to say that you can't find them in operation either. Yes. Doesn't mean they're in compliance with law. They just haven't been challenged. This leads into Kirsten's question. Are persons afflicted with COVID-19 disabled for purposes of the Fair Housing Act? Appear that they probably would. The 88 amendments, physical and mental impairments extend to persons with communicable diseases, at that time AIDS and HIV, and HUD did in the regulations included HIV infection, and persons with COVID status may have a record of a disability or regarded as having had a disability. Probably it is covered. Where it gets a little questionable would be if it's a permanent disability. It doesn't say permanent, but it's kind of more in nature for most people, not everybody certainly, but it can be a temporary disability. That's where it comes in. There's guidance, for example, pregnancy under Title VII. There's a Pregnancy Act which covers that. It's questionable whether a pregnancy would count as a disability. Certainly it's covered under familial status, but it as a disability net, so it's really unclear. But I think the concern with COVID-19, either if it's not a disability, It's a person with a record of disability or regarded as having a disability. That's all covered under the definition of disability. Can they be asked if they have COVID-19? No. As shared previously, that's not one of the narrow list of questions that can be asked. So the answer to that would be no. Can you ask for the test results or vaccination status? Probably not, right? You can't ask about whether they have a communicable disease or ask whether they have AIDS or HIV, right? Should not require to disclose any medical conditions. Those aren't permitted inquiries. You can ask about someone's disability or particular type of disability only to inquire whether they qualify for housing specifically set aside for persons with a disability or particular type of disability. So probably not that you probably can't ask that. Mm-hmm. And again, this applies whether, down the road, God forbid, there's another pandemic or another, and there probably will be. I'm very, certain that this will happen again. Yeah. And then
very timely.
May current tenants be asked to their test results or vaccination status? HUD says no. Again, same thing. What they did is HUD interprets the questions that you can ask at the onset of the tenancy. That's what their regulation covers. Mm-hmm. But in the joint statements, they say, well, those same principles apply to questions you can ask of tenants in the midst of their tenancy. So probably no. Now, if someone is known that there's a known case of COVID-19 at a property, well, that's a little bit different. The housing provider should respond the way they would with anything of a dangerous situation, or as Liz pointed out, the direct threat analysis. You have to use the same kind of direct threat analysis. The housing provider can require actions be taken consistent with CDC guidelines to quarantine or implement proper safety features, but they can consider also warning residents of the risk so they may make their own decisions as to precautions. The question came up, I won't list the city, but tenants wanted to know information on what tenants had COVID or what floor they were on, and you can't share, housing providers cannot share medical and health information with other tenants. They have to keep it strictly confidential. Mm-hmm. And it's not information, this is from the 2020 policy as to assistance animals, but applies here as well. Information relating to an individual's disability and health conditions must be kept confidential, cannot be shared with other persons unless information is needed in evaluating whether to grant or deny a reasonable accommodation request unless disclosure is required by law. So no, you cannot share that. And what if someone tests positive, follows CDC guidelines, and then if they don't, refuse to do it, and it's really a sad thing, but it does occur. Mm-hmm. People won't take precautions, won't self-isolate. It's just terrible. They go to the mall and do all kinds of things. But again, that gets analyzed under the direct threat exemption. And as Liz pointed out, it cannot be based on generalized stereotypes, fears, speculations. You have to consider these three factors. And those are the ones that Liz pointed out. But before even doing anything based on a direct threat, urge people to get legal advice. The direct threat exception is typically, that exception is narrowly viewed by courts. Mm-hmm. They don't automatically. Why? Because it's so tied to someone's disability. Mm-hmm. If you go real far with the direct threat, you would then eviscerate all the disability protections. The courts are careful not to do that. So it has to be really documented. But again, that would be something for a housing provider to get legal advice on. And one last thing, any housing provider should review and update their insurance coverage. Make sure that they are covered for insurance.
Yeah. Good homework assignment there. And then also just some resources that we will, of course, make available, some statewide groups. I think it's great to stay up to date with information on resources so that you are prepared instead of kind of caught unawares and scrambling. There's a lot of advocacy groups, there's a lot of resources, there's a lot of training. And I check out Micah's training menu on a separate plug. They just do such great education, and a lot of it's available online and at your own time. So I really recommend you connect with various groups so that you're keeping up to date and have the most current information in terms of how to meet the needs of people with disabilities. It's our number one basis of complaint in terms of volume of complaints. Steve, what's your number one basis?
Same, disability.
Same. Okay.
Be about 50%. Race would be about 33, another third.
Okay. We had 119 disability-based cases in 2021. Okay, so deep dive a little bit into assistance animals. I'd like to share this. Do you want to set this up or should I just play it?
Well, this is not make-believe. It's a real complaint that came in. Someone asked for permission to have an assistance animal. And this is a call from the manager. And this is actually what she said.
All right.
Hi again, this is Rhonda. I'm sorry, but when we discussed the dog, you were well informed that you're not allowed to have a dog. Whether it's a doctor order for emotional support or not, unfortunately, you may not have a dog. If the dog is there, 1 minute, 1 hour, 1 day, you are evicted. I'm very sorry. You might want to make other living arrangements because if in fact the dog is there, I will have to evict you. Thank you.
First of all, very clear. Second of all, evidence, right? Voicemail.
Correct. Yes.
Again, not an attorney, but this is evidence.
Hi again.
Oh, let me get a. So, do you want to talk a little bit more about that case, or?
Oh, it got filed, and
okay.
Attorney took it. And what happened is he certainly had significant disability, and after receiving that voicemail, he left the unit. He went up north, and unfortunately, he passed away a few months later. But he left. He could not be separated from his assistance animal, and that was it. So it's very sad.
So tragic outcome there.
Yeah, they then, I think, recanted after a couple weeks. Oh, we made a mistake, come on back. But that time he had already left and already moved.
Yeah.
Violations aren't necessarily fixable. They're still a violation. Anybody who has a question about that, I would think about, I always use, race and murder examples. If someone kills someone, I'm not doing it anymore. I'm not going to kill anybody. Well, you still killed somebody. There has to be a punishment. If someone thinks a civil rights violation is, quote, fixable, once they stop discriminating, everything is okay. No, it doesn't work that way. If someone takes that position, then they have a very low regard for civil rights protections. Once that was said, that was an act of discrimination. It was a denial of reasonable accommodation request. It was making housing unavailable to someone with a disability, and that's a violation. Now, whether they correct it later, that could be a factual analysis going to the amount of the damages, but it does nothing to correct the violation.
Right. And we've seen a number of clients just say, okay, I'm not going to try to renegotiate. My lease is up. I'm done. Fighting for this is an additional burden that they shouldn't have to face. And this is something that HUD really tried to address very thoroughly. This January 29, 2020 guidance is 19 pages long. It includes an addendum that can be detached and used to educate healthcare professionals, educate advocates, persons with disabilities. It does establish that there are two types of assistance animals. One, service animals, really for the primary purpose of this analysis, they're looking at service dogs. There is a small history where miniature horses have been used as appropriate as trained service animals. They can live and work longer. People who are allergic to dogs, for example, can't rely on a service dog. And then it creates a much larger, broader category of other trained and untrained animals that do work, perform tasks, provide assistance, or provide therapeutic emotional support for individuals with disabilities. They call that animal a support animal. I still tend to use assistance animals because I think they should really be treated the same. They are necessary because of a disability, and they provide some sort of support. So this guidance is a if this, then that type breakdown. It will ask what information you have at which point and give advice on what you might do next. We at our Fair Housing Center wrote a companion guide to this set of guidance from HUD. It starts with a really basic question. Is it a dog? And then is it a trained service dog? And then it moves through, if it's not a dog, if it's not a trained service dog, then it moves into support animals and additional questions that might help, focusing on the presence of a disability without a significant amount of detail, no medical records, no diagnosis, no prognosis, simply verifying that this is a person with a disability as defined by law, and verifying that there's a disability-related need for this animal or animals. For the first time in this set of guidance from HUD, we do see types of animals addressed pretty clearly. They say that dogs, cats, small birds, this list here at the top bullet point of other small domesticated animals that are traditionally kept in the home for pleasure rather than commercial purposes generally are going to be reasonable to have if they are substantiated. Reptiles, other than turtles, barnyard animals, monkeys, kangaroos, and other non-domesticated animals are not considered in that first category, but they might be considered as unique animals, and therefore there might need to be more information requiring or demonstrating how this unique animal is necessary for this disability-related therapeutic need. I think it gives a really good example of a capuchin monkey who's trained to open water bottles, prescription bottles, something that a golden retriever service dog cannot do. So it's not an automatic no if it's a unique animal, but it does need verification, which makes sense. Throughout, HUD emphasizes, as with all accommodations and modifications, these really should be interactive processes with sharing of appropriate information, with individualized consideration. They're very clear that HUD has really put forward housing providers may not insist on specific types of evidence if the information that they are given answers the questions, which I think is really appropriate. We've seen a number, and countless probably, cases where housing providers are asking for the disclosure of details about the diagnosis, the severity of disability. I've seen a case where they asked for the list of medications, the list of hospitalizations, the list of failed treatments, her prognosis. They wanted to interview her doctor, all for an assistance animal. It's a very limited exchange, and it's important to rely on this guidance. And remember that if any request for an accommodation or modification is going to be found to be unreasonable on behalf of the housing provider, they have to offer alternatives. So what is the alternative if this assistance animal is not found to be reasonable under the few caveats where that could be established? One of the questions we had post class last year was, how many animals can somebody have? And the answer is, it depends. There's no set limit in the guidance. It does say that it's going to address it, but it really doesn't. And I think it's best that it doesn't, because it depends. It depends on what the need is. And there's a number of cases where it's been successfully substantiated, where a person has a service dog that's trained and does specific sets of tasks, and they're also utilizing some sort of emotional support assistance animal. But for multiple animals, it's based on the need for each animal or what support that the multiple animals can provide. Sometimes it's the repetitious care of a certain number of animals that provides the therapeutic relief. There's been a history of those types of cases. So it's likely reasonable to establish that need through an interactive process. What does each animal do? Have that substantiated by a third party, unless the need is known or you can observe what the need would be. It's really important for owners of assistance animals to take control, maintain control, care for the animals, clean up after the animals, or arrange for that to happen. And there's no exception for aggressive behavior or damage, but you can't proactively, as a housing provider, say no with the expectation that this certain type of animal or breed is going to do this damage. So they've clarified a large number, I think, of the more common questions. But that doesn't mean that there aren't unique ones. I think I had a phone call from a housing provider who observed 5 snakes in an apartment once, and she was concerned that they were going to be requested as emotional support animals. That wasn't the case. They were purely pets. But she was ready to do her homework in terms of asking those questions.
Liz, our office has a pending case involving emotional support chickens. There's 6
chickens. Okay.
The city is willing to go up to 2, and he has 6.
Uh-huh.
And there was a case out of Florida where, I guess, I don't know, 10, 12 years old, had chickens, and the municipality took a different approach there. They amended the ordinance to allow him to have his chickens. That's not occurring here, however.
Okay.
But some of the arguments they're making, one argument, for example, they made, well, they can reduce property values. They're claiming that. And there's cases that have rejected that kind of an argument when it comes to assistance animals.
It's a changing thing, I think, and there's a rich history of cases. So, if you're advocating on behalf of someone to have an emotional support or multiple assistance animals, really, I recommend engaging with a fair housing center. Our center does help make those types of requests, helps kind of provide the guidance to healthcare professionals. We've got a fact sheet on how healthcare professionals can provide good information without too much information. So there's lots of resources available to this, but they are really case by case. Generally, once a housing provider has documentation, they should respond within 10 days. They may want to maintain a list of where animals, accommodations for animals have been granted, especially if there are no pet property. You don't want to have maintenance staff, for example, wondering why Liz has a cat in the window. When that conversation has already been had, you don't want to repeat. And really an important takeaway is these are not pets. Equate them to, a walker or a wheelchair. They really should not have any sort of pet language, pet treatment, pet limits, pet fees, etc. I'm watching the clock, so I want to move us pretty quick through here. But generally, documentation of every step, every request, every exchange of information is a really good thing for the advocacy side and the management side. We've already talked about the importance of keeping medical and health-related information confidential. And really, I just want to encourage that we listen to people with disabilities, making the requests, whether it's assistance animal or other, as they have the most accurate knowledge about what's going to work for them. Case here, it looks like, Steve.
Yeah, this one, well, by the way, I put in the chat a little paper on multiple emotional support animals with case citations and that. So
thank you.
Yeah, this is a case study, just real quick. The housing provider required a completion of a doctor's prescription form, and it said property would not be accepted. The property would not accept this form unless every field is filled in, and the housing provider requested doctor's insurance information to cover any damage or injury caused by the animal. And they also maintain a list of dog breeds not permitted based on the defendant's belief that those types of dogs have propensity to bite, including pit bull terriers or any mix or hybrid. That's an example of what? Unreasonable requirements. Some say, well, the doctor you have to certify that you're going to come in and testify as necessary. Doctors are not going to do that. They don't have the time. Mm-hmm. That's an example of how the violations occur.
Yeah, and the HUD guidance is getting at some of that. You can't threaten the person who's providing the substantiated information with that request of sign this form under the penalty of perjury. They've discouraged that information in the HUD guidance.
Yeah, this comes up all the time. When does the ADA apply? Because it differs when it comes to support assistance animals under the ADA as opposed to Fair Housing Act. The ADA is limited to 12 places of public accommodations. It includes places of lodging, inns, hotels, motels, place of public gathering, rent sales and rental establishments, service establishments, social services center establishments. And you can see place of lodging, inns, hotels, motels. Well, those are the things that are not covered under the Fair Housing Act. A gray area, for example, some people go to a motel and they may want to stay there 6 months. So with the lack of housing, that's becoming more and more common, unfortunately. But typically it has to fit within one of those 12 places. And the key thing is it has to be open to the public. I think it's on the next slide.
Okay.
We'll go up to the previous slide. Go back on one more. I'm sorry. And then social service center establishments, daycare centers, senior citizen centers, homeless shelters, food banks, adoption agencies. You can see where that overlaps a little bit with fair housing. Mm-hmm. Okay, on the next slide, the difference is here. Can a place be a place of public accommodation covered under both the ADA and the Fair Housing Act? Yes, it can be overlap. It can still be a place of a dwelling under the Fair Housing Act and fit within one of the parts of the 12 categories of place of public accommodation. Here is the illustration. This is from Department of Justice Technical Assistance Manual. A private LM Inc., a private non-sectarian nonprofit organization, operates a homeless shelter permitting stays ranging from overnight to sufficient length to result in coverage as a dwelling under the Fair Housing Act. Because it permits short-term overnight stays, it's a place of public accommodation as a place of lodging under the Title III of the ADA. In addition, if it provides enough level of other social services, it can also qualify as a social service establishment. So there you got dual coverage under the ADA and Fair Housing Act.
And that's the Americans with Disabilities Act, ADA,
Yep.
and the FHA, Fair Housing Act.
And does it apply to common areas within residential dwelling facilities? For example, a swimming pool, or what's another one?
Mail room, laundry.
Community center, like that.
Oh, you're saying public, sorry. Yeah.
Yeah. Only if it's open to the public. If the pool is only open to tenants and their guests, it's only going to be covered under the Fair Housing Act. Same thing with the community center or room or whatever. Yeah. If it's offered to available that anybody to the general public can use it, then it's ADA. If it's restricted, typically they're going to be restricted to tenants and their guests. It's only covered under the Fair Housing Act. A complex containing a rental office is a place of public accommodation because it's a rental office. So if the resident manager meets people in his or her front room, that's covered under Fair Housing and ADA. The rest of the rooms in the unit would only be covered under the Fair Housing Act. A curb cut, would that be under the Fair Housing Act or the ADA? Well, the question is, who uses the parking lot? If the parking lot is restricted to tenants and their guests, if the curb cut is a fair housing issue, it's not ADA. But all the time people say ADA. All the time. They almost say they do primary coverage under the ADA. When the flip side occurs, the ADA is modeled after the Fair Housing Act. The Fair Housing Act on the design and construction only covered new constructions of multifamily dwelling units, 4 units or more attached. The ADA, if it's a renovation, it's not covered under the Fair Housing Act. When it comes to the ADA, there's 3 standards for existing dwellings, dwellings that are being modified, and new construction. So it's very different in terms of the design and construction requirements. For ADA coverage, I just jump right away to the technical assistance manuals. I think that's the way to go. And if I need more information, then I'll go to Titles 2 and 3 of the regulations. They'll be referenced in the technical assistance manuals. When it comes to dealing with service animals, then you look at under the ADA. I think I have it on the next slide. I believe that, yeah, when it comes to Title II regulations, when it comes to private places of public accommodation, it's a restricted definition of service animal, only includes a dog or miniature horse, and it has to be trained to work or perform tasks for a person with a disability. There is no right to an emotional support animal in a place of public accommodation. That's under the ADA. There's an unpublished Michigan Court of Appeals decision which refused to make a definitive ruling. So we don't know how Michigan courts will fall on that question. But right now, I mean, under federal law, there is no right. They can permit it, but that's all. It's with permission to have an emotional support animal. They do have an absolute right in a place of accommodation to have a dog or miniature horse. And then to summarize real quick, common misunderstandings. The reasonable accommodation request can be made by anybody. It can be made by Liz's office, our office, anybody. It can be oral. It doesn't have to comply with written forms and procedures, though the best approach is to put the reasonable accommodation request in writing. You don't have to mention Fair Housing Act or reasonable accommodation. You look at what they're really getting at to see whether that qualifies. They're not excluded if they use the word pet or misstate what they're asking for. And you can't ask, the housing provider can't make a blanket request for information, can't charge a pet fee. Most of support animals, service animal is not a pet. Assistance animal is not a pet, right? It's an assistance device. Persons with assistance animals cannot be restricted to certain buildings, can't impose weight and breed restrictions, and the unwarranted verifications do not necessarily have to be made by a doctor or other medical professional. I'm working on a case right now with the Michigan Supreme Court dealing with emotional support animal. Hopefully that's going to be ruled on favorably. And they can't insist on burdensome requirements, such as being carried under the physician's insurance policy, et cetera. If you have see these kind of things occurring, report it.
Mm-hmm. Yeah, reach out for help. And like I said, we've got lots of information. So we've got about 15 minutes or so left before I have to head out. So we're going to cover domestic violence, and Steve's going to share some information about evictions and lockouts. So I'm going to move fairly quickly because I want both of these to be covered yet. And just give a quick overview of protections related to domestic violence. I think there's some questions in the Q&A about this.
Yeah, I want to make sure I get to all the questions.
Yeah, domestic violence cases in private housing have been successfully filed under the existing gender protections of the Federal Fair Housing Act, which, remember, covers, you know, all housing, whether it's federally funded or private, with all the nuances and exemptions we've discussed. The Violence Against Women Act, or VAWA, provides specific protections for victims of domestic violence, dating violence, and stalking, applying only to federally funded public housing authorities and participants in the Housing Choice or Section 8 voucher program and project-based programs. And we've got more detail on that coming up here. So applicants and tenants of HUD housing programs who are victims of DV, dating violence, sexual assault, or stalking, they're not limited to women. This is a great point. The protections apply to all without regard to sex, gender identity, or sexual orientation. VAWA also grants protections to the abused spouse or child of a U.S. citizen or a lawful permanent resident, including the right to self-petition for a green card. Victims of all four categories cannot be denied admission or federal rental assistance just because they are or have been a victim or a threatened victim, cannot be evicted or lose their assistance just because they have been or have been threatened as a victim, cannot be denied admission or rental assistance, evicted, or lose their subsidy for reasons related to the abuse, such as having bad credit history or criminal history. So again, this is VAWA protections, which might have answered one of the questions in the chat, but here's a more specific definitive listing. You can see it's a broad cross-section of a lot of the housing that is made available under HUD and various programs, rural development, applying, of course, certainly to some McKinney-Vento, which is important, emergency shelters, oh, that's old language, emergency solutions grants, home grants, housing trust fund, COCs, low-income housing tax credit or LIHTC housing. It requires, again, under those covered properties, that communities honor abuse protection orders and other court orders like divorce decrees that especially address access to or control of the unit. Communities have the responsibility to inform individuals of their rights under VAWA and include that information in lease agreements, and I would say in other places. In cases where both the victim and the perpetrator are parties to the lease, the law permits the community or the apartment group to split or bifurcate the lease in order to evict the perpetrator and allow the victim and any other innocent family members to remain housed, which can be very critical to not exacerbating an already difficult situation.
Hey, Liz, if you back up for just a second,
Sure.
Michigan doesn't provide for that. I don't see where we can compel the at least to be bifurcated or split. Is that the permission of the landlord? I wish it did.
Yeah, a gap there.
Yeah. So we go to the next one. This is under Michigan statute. Provides for early termination for tenants or their children who have reasonable apprehension or danger of domestic violence, sexual assault, or stalking. The requirements are set forth. They have like a form, notarized form that you can use. We have it in our office. Liz, you probably have it too. But it's under the statute, and it really requires strict adherence. It has to be notarized, verified by a qualified third party. I believe there must be a police complaint filed. So it's really strict requirements. But it releases the tenant victim from an obligation to pay rent no later than the first day of the second month that rent is due after the notice is given. But it can be a difficult process for a individual tenant to navigate. They have to really strictly comply with it.
Some sample best practices, which I think are best practices regardless. This came from a Virginia Fair Housing Center. I thought this was beneficial in terms of thinking about making sure properties are well lit, safe, and secure. Of course, completing repairs, especially repairs that would allow for easy access, broken windows, broken locks, prioritize those, get those fixed in a timely manner. Acknowledging, again, those protection orders and helping enforce them, excluding a violent person from the premise, assisting in the pressing of criminal charges, being very cautious about victim information, contact information, not allowing that to be released really at all unless required, and recognizing that domestic violence is not a lease violation. I think we have a question about can a landlord
ask if applicants have been victims of a crime, specifically domestic violence. Mm-hmm. That's why I come back to that same regulation. Is it a permissible inquiry? Mm-hmm. No, it's not. Nope.
That was
a criminal record check, but that's it.
Right. Collecting information about what they've been a victim of is a red flag. What can we do as service providers if property managers or landlords refuse to sign VAWA addendums? I'd be curious if that policy was equally applied consistently across the board, or only for certain races, or favoring a gender. I'd also want to know what's the basis if they give you one. I don't know that we can force them to sign the addenda. I think from the fair housing perspective, it would be, are they doing that equally across the board?
Well, I could say from a disparate impact case,
mm-hmm.
right? It'd have an adverse impact. I mean, statistically, I think it's what, in the mid 80%, the victims tend to be women. I think there's maybe 10, 15%, hard to say. Mm-hmm. There's an increase, with men being victims of domestic violence, but typically they're challenged that it's having an adverse impact on women because they tend to be the victims of domestic violence and would need a VAWA protections.
Mm-hmm.
So that would be chargeable as a fair housing violation. Again, all we do is we help make housing available to everybody. We increase housing, and people can comply willingly, or
or not.
They get educated.
So report it is what I'm hearing. Is let your fair housing center know. Yeah. And I will turn this over to you, Steve. I'm looking forward to this section. This is not an emphasis I have.
This comes up so much.
Super important.
There is no right to self-help. And self-help is where the landlord changes the locks, threatens the tenant, does something to avoid having to go through the eviction process and get the tenant out without going through the formal eviction process of giving notice, and then going again. Notice is required 100% of the time. There's things where maybe it's not required, but typically there's a requirement for notice to be provided. And the policy is clear. It will reduce violent confrontations between landlord and tenants. That was the whole purpose of the law. And that goes back many, many years. So Michigan passed the anti-lockout statute to prohibit landlords from resorting to self-help, even where the landlord is entitled to possession. Instead, they have to go, if the tenant doesn't move out, the landlord has to go through the judicial process. And the tenant can recover treble damages if there's a forcible ejectment. Like turning the water off is not, but if there's any kind of force involved, the tenant can get triple damages, as well as actual damages for other types of interference. Also, if the landlord engages in self-help, they're not permitted to get a judgment of possession. The time limitation is the tenant has 3 months in order to bring a case in circuit court to be restored to the premises. If they're comfortable going back into a place like that, they have a 1-year limitation period on suing for damages from the landlord. And I have a list on the next slide is what constitutes. There's a lockout, meaning I got the anti-lockout statute. I don't know if I have the list of the factors. May not have put it in here. Nope, I don't have it in there. I probably need to show it. But I can tell you this, these are landlord's violation. And one of them is primarily because the tenants attempt to enforce rights under lease or agreement. Primary is a penalty for complaint to a government authority. If the tenant complains about repairs not being done or violation of the health or safety code, that's a solid defense to a judgment of possession. And here, that the plaintiff committed a breach of the lease, which excludes the payment of rent if possession is claimed for another. even though courts don't always look at it, the landlord is required to keep the property habitable. If they don't keep it habitable, they lose their right to collect rent. And if the landlord then moves to evict within 90 days of when the tenant attempted to enforce the rights, then it's a presumption of retaliatory eviction. If it occurs after 90 days, for example, maybe 3, maybe 5, 6 months later, they just do a non-renewed. It doesn't mean you still can't claim retaliatory eviction. You just don't get the benefit of the presumption. And by the way, I meant to put it on here. I guess I just slipped. What constitutes an unlawful lockout is turning off denial of heat, water, power, electrical, introduction of noise or other nuisance or anything that makes it impossible for the tenant to have the full enjoyment and use of the property. That's considered a lockout. Of course, changing the locks would be clear, a classic violation of as well. Those kinds of things. Removing the tenant's property would be another thing that would constitute a lockout. There's a whole list of things that constitute lockouts. And I think I'm seeing more and more incidents in which landlords are resorting to self-help.
So important for people to know their rights. And this is closely tied to the group, that we're talking about today.
Oh, absolutely. And when this occurs, what happens to a person, right? And many live in fear. They live in fear of their landlord, but many that are, I don't know if there's a homeless person that hasn't been a tenant at some point, maybe some. I suppose people have gone from home ownership to homeless, but often they're marginalized tenants that then are thrust, or for various reasons, it could be mental illness, but then are into a state of homelessness. I want to make sure that we're doing everything we can to keep people in their homes.
Yeah, absolutely. So lots of resources available on both our websites. Steve's got a ton of upcoming training and information as well listed. I think we've got our links and all this we can share with everybody as a follow-up, but there are a few questions that we did not get to. First one is, are there initiatives underway to get returning citizens as a protected class? And I'm not entirely sure. Hopefully, Nina, you're still with us to provide a little bit more information on returning citizens. So if you could chime in with that, that'd be helpful.
I would assume she means returning from incarceration.
Returning from incarceration. Okay. Is there a movement to get folks with a criminal history protected? In Michigan at this time, not that I'm aware of.
Yeah, I'm not aware of it at the federal level as well, other than what we talked about.
Right, and within certain communities, there's some fair chance ordinances, and it's limited. I think Ann Arbor and Kalamazoo might also have some ordinance language. So again, connect with your local fair housing center to get a little more information on those.
I want to clarify too. I should clarify too. Just because it's, for example, someone is a violent felony, for example, that would be one that would not be covered under the Detroit ordinance. There's no protection there, but they're still subject to the requirements of the Fair Housing Act. Because we have a case where we filed it where someone could be, the violent quote felony could be 30 years ago. And to use that to turn somebody down for housing would be a violation of the Fair Housing Act, even though it would pass as a ground to turn somebody down under Detroit ordinance. So they're subject to both federal and state requirements.
Yeah. Can you have a policy that is for senior housing that is 62 and older, and if they are all housed, go to 50 and older, not 55? Go ahead.
Yeah, we had a case where they put a separate policy of 35 and over. That HUD has a Q&A on it, and it says that they do it in many states, except a state that has age protection. So that would be a violation of, it would be fine under federal law, but it'd be a violation because there's no federal age protection law. It would be a violation of age discrimination under Elliott Larson. So for 62 and over, they cannot do a separate second age rule. And again, there's blogs where attorneys recommend it. but that only applies to states that don't have age discrimination in housing. So no, they can't. The only qualification would be there's some MISTA programs, for example, that are set by state. The state MISTA sets where it's housing for people 50 and over and things of that nature. If it's under a qualified program by HUD or at the state level, it's fine. But other than that, no, they cannot do that. But again, your example, 62 and over, it has to be 100%. It would be a situation where it's 55 and over, where they have a second age rule. 62 and over, it has the 100% rule. If someone is 63 and they marry somebody who's 61, they must leave. She can't be there, or he can't be there if they're under age 62.
Yeah.
So this is really a 55 and over question.
Yep.
Hope I answered it.
Yeah, no, that was great. My short answer was going to be no, but you provided a lot of context, and it shows, you know, each possible scenario, it needs to be kind of walked through the different layers and the different steps, and geographic.
Well, in our situation, they took the brochure said 55 and over. They whited it out and put 35 and over.
Oh. And
the complaints were 21 and 22, 4 people they wanted to occupy a unit, you know, kind of, and share it. And they said no. Then he had his mother call. She said they told her no, her son can't live there. And then we sent testers out. They were told the same thing. Then they said, oh, that was just one rogue agent who did it. That's not really our policy. Well, it turned out there were 2 people. And then later on, after the case got filed, they called us to do training. Of course, I said, what's this about? Oh, you know, there were a couple people that did it, but they're fired and they're not with us. So we want to train. I say train. Oh, the attorney told our attorney that the people were fired. But then I got a call where an agent from there was asking for training. I said, what's the training about? Well, we need 2 people that need training on fair housing. And then he went into more detail. I said, wait a minute, we're the plaintiff. We obviously can't do the training. I said, you want to go to another group? But turned out they did not fire the 2 people. That was a lie as well. So these are the kind of things that go on.
Oh, God.
Not very credible.
No.
Liz, it is after 2. I know you had to go. I don't know if you want to stay and
it is after 3.
The last 2 questions, Steve, or we just should end.
I can go to no, we can answer.
Okay. I'm so apologetic. I do have to pop on.
No, that's fine.
Well, thank you both so
Thank
well.
you.
All of you. Thank you so much. This was so great. Really appreciate the partnership and good information. I'm going to stop sharing my screen because that is my piece. And thanks very much. We'll follow up soon.
Okay, thank you.
Thanks.
All right, we have 2 questions left, Steve. One, when
what if those using drugs have mental illness as well? I think we're saying is current illegal abuser also has a mental illness, right? Because they'd be excluded as a current illegal user. They would not be covered under the Fair Housing Act, period. So they're still not covered.
Okay, and then
but I would address, I mean, that situation, have somebody get the treatment that they need to no longer be a current illegal abuser, and then they would have the protections of someone having a mental illness.
Okay, and then
can a landlord say their property insurance will not allow a breed of dog? Yes, they can, but they cannot enforce it as to a service or assistance animal. An assistance animal would include emotional support animal. I had a case where it was claimed a pit bull, and it could be weight. This time it was a breed. It was a pit bull, but the landlord said no, and they inquired as to their insurer, and the insurance company said no. If you allow it, the insurance company said, well, if you don't prohibit certain breeds, your insurance will be canceled. So the case was filed against both the housing provider and the insurance company, and both ended up having to pay. The housing provider had insurance, but that same insurance company, so they paid $20,000 came from their insurance company, and then the insurance company paid $20,000 for themselves, And they then had to rewrite their policies to say that they will not impose breed restrictions on service and emotional support animals. So no, they're not allowed to. And under VAWA, how would a prospective tenant attest to the correlation between housing barriers, poor credit, no credit, and their domestic violence situation? I'm not sure. I think under VAWA only would cover the domestic violence situation. If they're being turned down for poor credit, no credit, then that would be a separate consideration. I guess, without getting too technical, with a mixed motive type situation. HUD does not like us to get into mixed motive. For example, would the decision have been made to turn somebody down because of their no credit, poor credit, irrespective of their domestic violence situation? That's something that could be asserted as a defense. But if they're still turning someone down based on domestic violence being a victim, that still would be a violation. That's how I would treat it. Under fair housing law, that requires direct evidence. In employment discrimination law does not require direct evidence. That's a difference between fair housing and employment. Hope that answers it. Still report it, still do it as a violation.
Okay, so that is all the questions we have. So I really
and we have to get the PowerPoint out to everybody. I'm going to add the slide that was missing on. It will specify the various kinds of actions that constitute an illegal lockout.
Wonderful. So again, I want to thank Mishta for paying for us to have the time here today. And I want to thank Steve and Liz again. I want to thank all of you, especially the 177 that stayed up until 3:06. That's remarkable. A lot of good information today. Again, this webinar will be posted to Micah's YouTube channel after the fact, so you can share it with colleagues or revisit if you would like. And we'll have a survey that will pop up on the screen when you log off. It's super helpful to us if you fill that out so we can make sure that we're providing the best content to you. And I wanted to let you know that we have 2 more trainings this month. We have the HUD's Equal Access Rule and Practice, which I put in the chat. And then we also have Mindful Leadership. Nope, that's not true. It's Workplace Wellbeing. So that is on the 20th about and if you want to attend Workplace Wellbeing for free and you are having an April birthday, the first person who puts their email in the chat, I can get you a free registration. Oh, looks like Jessica. Happy birthday to you, and you'll be getting a free registration for that. If anyone else wants to attend, the information is in the chat. So with that, I'm gonna end the webinar and thank you all again so much for your time. Have a great day. Bye-bye.
Thank you.